Go ahead.
Hi, thank you for joining us today. I've got my partner and good friend Rob Sedgatpour from Stratco Property Group, and we've also got Nativ Winarski from, I'm hoping to pronounce this correctly, Marie Winarski Bittens. Is that correct, Nativ?
Yes.
Okay, great. Thank you for joining us, Nativ. So I just wanted to give you recent findings. I specialize in investment sales in the Bronx, and I just wanted to give our findings of what we've been hearing back from our clients. You know, it's been, since COVID, there's obviously been a whirlwind of landlord and tenant legislation, you know, what best practices are. Two particular feedback I had is what they're supposed to do with non-payment cases and best practice for any pending evictions going forward. So maybe we'll start with the non-payment of cases and how it's best to approach that.
Sure. So there are, I'm sorry, go ahead, Robert.
Yeah, Nativ, just to give a background, you know, we face a lot of changes within the space with the rent laws that passed in June, and given the fluidity of what started with COVID and legislation that came into effect then, between I guess then and now, what would you recommend if a landlord has, say, 10% of their building that's behind in rent today, or in some cases in Manhattan it's higher? What do they start a case now? Do they wait for the courts to open up? What are they going to gain by starting the action now? Are they going to get an index number? Are they going to get a court date? Is there going to be a Zoom session? What are the benefits of starting now, and what would you outline as best practices within that space?
So I do think they need to start the case, especially because courts are open now. And they can start the cases, whether that be residential or commercial. There are different mechanisms involved in each. Right now, when you file the case, you do it by mail. But I am expecting that the courts are soon going to allow that electronically. You should get a court date within a couple of weeks after the filing, and we'll see how the court deals with setting the first court date or the second court date thereafter, assuming they're not represented. But it is important to start it, because otherwise, if you don't, because of the backlog, there's going to be thousands, tens of thousands of cases in the queue. And so if you just sit there and just wait for things to further materialize or reach a speed which is more expedient, and then you're going to be way behind in the queue, and it's going to be months before you get your case on the calendar. So I would definitely advise clients to start the case as soon as possible, assuming their arrears outstanding.
Is it more beneficial for both the tenant and the landlord, for the tenant, if he can prove it, that his filing for some sort of economic hardship or financial hardship under something that you mentioned previously called the Safe Harbor Act, and how does that impact these types of proceedings, and what is a Safe Harbor Act?
So the Tenant Safe Harbor Act allows a tenant to assert a defense that they face financial hardship, and if they're able to prove that, then the relief that is afforded the landlord will be limited to a monetary judgment as opposed to a possessory judgment. If they're unable to prove it, the landlord will get both. If they are, they get the money judgment. But either way, it allows both parties, the tenants and the landlords, to figure out exactly what their rights are, to the extent that the rent is deemed outstanding, and even if the tenant is able to establish that they face financial hardship, the landlord will still have a remedy by way of the money judgment and be able to collect thereon.
What are we doing differently today with starting a non-payment case versus late February, pre-COVID? Outside of the COVID investigation.
Well, what's different today, the world is completely different today, but apart from the fact that the courts were functioning, how well they were functioning is a matter of debate, but apart from the fact that they were functioning and you had in-court appearances, you weren't limited in the type of relief that you could seek, which is a money judgment, a possessory judgment, dependent upon whether a tenant is able to prove financial hardship. And the other issue, at least as it concerns commercial tenants now, is if you were to start a proceeding in Part 52, with the commercial part, you still have to submit an affidavit that you made an investigation as to whether the tenant has suffered financial hardship, and you'd have to file that affidavit for now, at least until August 20th, and that certainly didn't exist in February.
I had a quick question, if you don't mind. Are the city doing anything to prepare for all these expected cases coming in, like any more attorneys or judges provided to the tenants or the landlords?
Yeah, I'd like to tell you that the answer is yes, but no. And to the contrary, and I guess perhaps it's budgetary reasons, that because of the fact that it's this economic hardship everyone is facing, certainly the city is facing a financial hardship and is facing a financial shortfall. So no new budgets have been allowed, as far as I'm aware, to the court administration, and in fact, we may very well see the cutting of certain budgets towards the courts, which would further cause backlog and delay.
If we're commencing a non-payment proceeding now, I believe it's a 5-day notice. How long is it generally taking until the first court appearance?
Okay, so there's two things you would need to do. First, you file the 5-day notice, and then that notice just lets the tenant know that they're in default. Then you serve a 14-day notice prior to the June 2019 HESPA, Housing Stability Tenant Protection Act. That was a 5-day notice. Now it's a 14-day notice where you itemize the rent default. Then you file the petition, and you would file it in this instance by mailing. Hopefully in the coming weeks that can be done electronically. And as of today, we do not know how long it takes between the filing and getting the first court date. And this is because all of this is completely brand new. In fact, we were just able to start filing these cases on July 6th, last week. So we're going to see rather quickly exactly when you're going to get your first court date and how the courts are going to treat those court dates. Those should be virtual court appearances. We'll see if the court will take them, even if the tenant is not represented, because as of today, both parties had to be represented in order for courts to take these conferences. And so all of this is being worked out by OCA, and as we get further instructions, I'll certainly be happy to forward them to your attention. But right now, we have no information as to when those first court dates are going to be scheduled.
Anything related to holdovers?
Yes. So holdovers, you don't need the affidavits. So you can file them, but you still face the same problem as the non-payments, which is when you get your first court date. So you can start, there's nothing precluding you from serving the predicate notices, from filing the petition, and it's just a matter of when you get your first court date. But again, that may sound to some people as, well, maybe I should just wait and sit on my rights until the courts get their act together. But again, you would just be in the backlog, and it will just further delay things. So to the extent that you have the case, file it.
So before we go into the next topic, I'd like to give a little bit of background on the state of the market as far as investment sales and the liability that owners have, because Mitch was involved, Nativ was involved in the case that has impacted many of our buildings that had a history of some level of liability. Mitch, what's been the change with the level of investment sales, the liability that the buyers have been looking at when they're looking at deals, and what sellers are basically feeling are handicapping their sales?
Yeah, so unsurprisingly, investment sales has fallen off the cliff in terms of transaction volume. We just released our Q2 stats, and it's been the worst quarter worst in terms of transaction volume and actual transactions since 2009. There's a lot of a wait and see approach, as you can imagine, and buyers want to buy a discount. There are buyers out there. There's plenty of money out there, but they want heavily discounted pricing, which sellers aren't prepared to go to yet unless they have to sell, right? So, but I think in terms for multifamily specifically, the June laws last year had a big impact on pricing than COVID has had. So on average in the Bronx, I've seen on average 30% decrease in value. So you're seeing 5.5 cap go up to 7 cap in the Bronx. post the laws. But, you know, it's still early days in terms of pricing because there's not that many data points in the market. But I think, you know, they're really buyers are looking for good cash flow, good cap rates, and the only thing supporting the market right now is the debt market, the cheap debt available. So yeah, that's a quick overview of what's going on in the market.
So Nativ, as we both know from the owner operators and the investors that invest in this space, they were both handicapped with rent growth opportunities and value enhancement strategies, but also an increased risk on really a black hole of liability as far as how far back the look back period is, what qualifies an opportunity to go back really to the end of time as far as how the rent growth happened on a particular rent regulated unit. You were involved in the case, which I'll outline as Regina. If you can outline what really just sum up what that case was and really its on the ground impact on units and buildings today.
Sure. So when the new rent laws were passed in 2019, as Mitchell stated, that it significantly impacted market value. Among many reasons is that it was almost impossible to do a due diligence and find out what the extent of liability, because the courts were able to go back to year zero in effect and make determinations as to overcharge, which significantly increased the exposure for landlords. We argued a case at the Court of Appeals on January of this year, and a decision was issued on April of this year, in which the court found that the legislature enactment of HESPA and its retroactive application was unconstitutional. And so that was an earthquake of a decision. And so what it did is, on its on the ground implications, is there is now a new base date for the purposes of determining where an overcharge can begin, and that is June 2015. So when you're buying a building and you're doing your due diligence, you only have to go back to June 2015, assuming there was no fraud involved. And if there's fraud, there's other issues, but generally you go back to June 2015. And so now landlords know, or owners, prospective buyers know, when they're purchasing a building, this is the date I have to go to and make sure I have the documents going to that date. And it gives them a tremendous amount of security, at least going forward, so they can measure their liability.
Okay, so I think with all of the, I guess the bad or the challenging news and the issues with operating buildings today, many are looking at new opportunities, and the challenge we had over the last 12 months on how to do our underwriting or the diligence on acquisitions, you provided really a concrete level of what the look back is if there is a potential liability or risk, what the rent may get reversed back to, as opposed to it being a black hole. Because for many of us, we just didn't know what to account for, how to measure if a piece of documentation was missing. The last thing before we finish up, there was a big increase in the legal aid budget during the current mayor's tenure, and an increase with the legal aid presence, and they've had a big impact on what's happened within landlord-tenant litigation. With the change in the city budget or the challenges that they're having, have you seen any changes yet, or do you anticipate a change with the legal aid budget going forward? Or are you prepared to answer that or comment on it?
The changes that we've seen is generally that there's a lot more representation for tenants in the housing court. And what that does is it ups the ante in terms of potential liability in all of these cases that are brought by landlords. A landlord can bring a case, a simple non-payment case, for a few $1,000s and think, okay, what's my exposure? I brought a case for $5,000 for 2 months worth of rent. Worst comes to worst, I don't get my $5,000, but now we'll legal aid on the other side if there are any questions regarding the rent history, registrations, things of that nature, and now there's potential overcharges and treble damages and things of that nature. Things aren't so simple. And so landlords need to be careful, both as to the counsel they choose and to the cases that they bring, to make sure that their documents do line up. And now that we have that base date, landlords are able to do that and know exactly what the base date is and how to make a determination as to what the legal regulated rent is.
Thank you.
I think that's where we'll wrap up. Thank you, Latif. Really appreciate your time. Thank you, Rob, as always. I'll circulate our contact information with this video and look forward to speaking soon.
Thank you.